All right, welcome to the 294th District Court. My name is Judge Chris Martin. We're going to proceed with this afternoon's docket. Mr. Green, are you ready on Mr. Huggins?
We are.
Mr. Huggins, if you'll come forward, sir. This is cause number CR 2124, State versus Hunter James Huggins. All right, it appears that the state's wanting to withdraw its motion to adjudicate with the agreement that Mr. Huggins will consent to the modification of his community supervision to extend it for an additional 2 years with him attending the substance abuse felony punishment facility, also known as safety, as a condition of his community supervision. Is that correct, Mr. Green?
That is correct, John.
All right, Mr. Huggins, if you'll just raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you get put your hand down. Mr. Huggins, you are represented by your attorney, Mr. Steve Green. Are you pleased with his representation of you?
Yes, sir.
Like you had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
So you've heard me state what the agreement is between you and the state. Is that correct?
Yes, sir.
And has anyone threatened, forced, or pressured you to make you feel like you had to extend your community supervision and agree to the felony punishment facility as a condition of your community supervision?
No, sir.
Are you doing this because this is what you decided that you want to do in your case?
Yes, sir.
Mr. Green, you believe Mr. Huggins to be competent today?
I do, Your Honor.
And you believe that he understands that the extension of his community supervision is going to require him to pay additional fees and reporting requirements and all those things?
I do, Your Honor.
All right. So, Mr. Huggins, before I approve this, you're telling me that you've got a drug problem?
Yes, sir.
Okay. And what's your drug of choice?
Methamphetamines.
Methamphetamine. And how long have you been on methamphetamine?
About 3 years.
How old are you now?
I'm 26.
You're 26. And so if I approve this, you're going to go down to the safety program with a willingness to learn, to educate yourself, to get better, and take something from that program that will hopefully help you in maintaining sobriety when you get back. Is that correct?
Yes, sir.
I've had people go down to that program and learn and get educated and come back and succeed on probation. I've had people that go down there and they go down there with poor attitude. They go down there thinking it's the easiest way to get back out of jail and out of not having to go to prison. And they come back and they immediately relapse because they didn't learn anything. They didn't try. And it's a waste. It's a waste of time for everyone. And it's a waste of resources and beds for individuals who do want to go. Are you the type of person that's going to go down there, really take advantage of what they're offering?
Yes, sir.
All right, court will grant the state's motion to withdraw the motion to adjudicate. The court will extend Mr. Huggins' community supervision for an additional 2 years. The court will also order him to attend and successfully complete the safety program as a condition of his community supervision. All right, the court has signed the order. All right, so Mr. Huggins, you'll return to custody and you'll await a bed that becomes available. And when it becomes available, you'll be transferred down to that program. And I hope that the next thing I hear from you is from the probation department telling me that you went to safety, that you've complied, you've done everything, and that the next thing they want from you is for me to sign an order to terminate your community supervision because you've been successful. That's what everyone wants for you.
Yes, sir. Thank you.
Okay. Good luck to you, sir.
Thank you.
I say good luck. It's not really about luck. It's just a bad habit. It's not about luck.
Yes, sir.
It's about what? Hard work, accountability, responsibility, being an adult. Okay.
Yes, sir. Thank you.
So time to get to work.
Thank you.
Your Honor, that's on my business, ma'am. Excuse.
Yes, thank you, Mr. Green. Okay, I'll give you time. Mr. Manning, are you ready?
Judge, we are waiting on some thinking and we're told by security downstairs to go to different courtrooms and off locations.
All right, we'll wait. Mr. Sanders is talking with his clients. Just for the record, cause number CR 2201, State versus Michael Watkins. Appears to the court that this setting has been reset by agreement between the state and defense. The case has been reset for a plea on June 2nd. All right, Mr. Knoll, you ready now?
Mostly, at least I've made the call, Your Honor.
All right. This is cause number CR 21225, State versus Michael Paul Marley. Mr. Marley, if you'll come up, sir. All right. Mr. Marley is set on a hearing status regarding medical records. What say you, Mr. Knoll?
Judge, I sent to a Robin, that's Robyn, Priestley, a subpoena request to her fax number. She said she would accept it by fax. 903-676-4191, the custodian of records there at UT Health, East Texas, Athens, for Mr. Marley's medical records shortly before the incident that brings him to court today again. He'd had a surgical procedure there, and I've been trying to get those records. I left a mailing address for me. Now, maybe I need to throw a caveat in here. Changed mailing addresses. I gave her the new mailing address, but I'm getting mail at 2 different addresses. But I gave her the new mailing address. I also gave her my email, also gave her my cell number, and indicated that any method was fine and that I would pay costs. As far as I know, there's not been any records either emailed to me. I have not gotten any by postal mail. And the subpoena was sent at 2:30 on April 12th of this year. And I just tried to call, and of course, you get a recorded line that nobody's available now, and they'll call back. So, still don't have what I hope might help alleviate what the state is offered on this case. I'll just continue to try to get a hold of this lady and figure out what she wants me to do to get those records. The subpoena was sent, and I have a confirmation that it was in fact received at the hospital.
You're going to be seeking any other relief, writ of attachment, anything of that nature?
Judge, I hate to do that at this point in time. I don't think so right now. And it could be they emailed it and it's someplace in a spam file somewhere, but I'll continue to try to contact them every day until somebody can tell me if it was emailed or request was lost or whatever.
You're asking the court to reset this until June 28th. That's the next evidentiary document.
That works.
You available on June 28th?
I hope so.
You need-
And I hope I have those records with me. Let's just set it June 28th, Judge, and I'll keep working to figure out why I don't have them yet.
I'll tell you what, if we need to set it earlier, we may need to do that.
I'm fine with June 28th. If I get them earlier, I'll inform the court if there's a sooner.
We'll set that in the morning. I believe I only have AM settings that day,
June 28th, 9 o'clock.
9 o'clock.
And I'll stay on Miss Priestley to see what happens. I think that's all I have, Judge. My big deal.
Yes, thank you, Mr. Knoll. Mr. Sanders, you ready? Who do you want to call first?
Mr. Hansard.
Norman Wayne Hansard, CR 20339. All right, Mr. Hansard, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. I'm going to review your paperwork just real quickly. All right, Mr. Hanser, today we are set for sentencing in your case. You requested a jury trial. Jury trial was afforded to you. The case was tried and the jury returned a verdict of guilty, which was accepted by the court. And this matter was set for sentencing on this date. The pre-sentence investigation report was prepared by the Van Zandt County Community Supervision and Corrections Department. That's been tendered to your attorney, Mr. Sanders, and to the state's attorneys as well as to the court. It's my understanding that you're asking now that you be able to enter into a negotiated sentence recommendation with the state rather than having the court review the pre-sentence investigation report, listen to any evidence that you might want to put on regarding sentencing, and allow you to resolve the sentencing in this case by agreement. Is that correct?
Yes.
And in making that decision, you've discussed this with your attorney, Mr. Sanders. Is that right?
Yes.
And do you feel like you understand the decision that you're making today and all of the consequences that flow from that?
Yes.
Okay. And do you have any hesitation or questions that we need to address at this time? It's okay if you do. Okay. Are you pleased with Mr. Sanders' representation of you? All right. You feel like you've had enough time to discuss this issue regarding sentencing with him? And Mr. Sanders, do you believe Mr. Hanser to be competent to enter into this agreement to waive his right to appeal and enter into this agreement for recommended sentencing?
Yes, sir. I believe he is competent and understands that. And Judge, we did discuss the pros and cons about not reaching an agreement and still having his right to appeal, but then also the potential of getting a much longer prison sentence. And with 25 years being the minimum, that was a factor that was considered. And so, based on those different factors, I believe that he understands the pros and the cons of that proceeding this way. And I think that he's aware of the consequences of agreeing to this matter.
All right, Mr. Hanser, you've reviewed the indictment in this case with Mr. Sanders. Is that correct? You understand that the state of Texas has alleged prior convictions in this matter, which, if found to be true, would enhance the punishment range to that of a first-degree felony, which would increase the range of punishment to a minimum 5 years in TDC. I'm sorry, it would increase it to a minimum of 25 years confinement in the Texas Department of Criminal Justice to a maximum 99 years or life. You understand that? And so at this time, I'm going to ask you, Mr. Hanser, having reviewed the enhancement paragraphs, would you tell me that those enhancement paragraphs are true or not true?
They're true, sir.
All right. Has anyone forced you to plead true to either one of those paragraphs today? All right. The court will accept the defendant's pleas of true to the enhancement paragraphs. The court will find that the recommendation from the state of Texas is that sentence be imposed today on the charge of manufacture, delivery of controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams at 25 years confinement in the Texas Department of Criminal Justice Institutional Division. No fine, restitution in the amount of $180, court costs in the amount of $290, and reimbursement fees in the amount of $50. Court will find that Mr. Hansard has pled true to the enhancement paragraphs. Court will find each enhancement paragraph to be true, and the court will follow the agreement that the defendant has reached with the state. Court hereby imposes the recommended sentence of 25 years confinement in the Texas Department of Criminal Justice Institutional Division, orders restitution, court costs, and reimbursement fees, and the court awards Mr. Hansard 740 days credit towards his sentence for the time that he has spent in jail on this cause. The court also finds that the defendant has intentionally, knowingly, and voluntarily waived his right to appeal on both the issue of guilt and punishment in this case. Court also finds that the state has agreed to dismiss under section 1245 of the Texas Penal Code, taken into consideration with the sentence in this case, possession of marijuana less than 2 ounces, and a driving while license invalid with previous convictions. All right, the court hereby remands Mr. Hansard to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Mr. Hansard, I'm going to have you step forward to be fingerprinted by Deputy Police Sheriff.
Judge, if I may, just briefly, Mr. Hansard had a concern. There was an amount of money that was seized from him on the night in question. I've spoken to Mr. Sanders. We are going to help facilitate with the Wills Point Police Department, turning that over to Mr. Hansard's designee so it can be transferred to his TDC trust account. He has some concerns about going to the sheriff's office, and that's fine. We will help go it through a third person that he designates and trusts.
This is non-seized money.
A seizure was never turned over to the DA's office. It was never seized. We're well past all our statutory deadlines. We believe it needs to be turned over. We just don't want them to hold it for however long of his incarceration. That seems the best way to turn over those monies to him.
All right, so the DA's office is going to facilitate that. With
I will
Wills Point.
communicate with both Wills Point Police Department and Mr. Sanders, get whoever Mr. Hansard would like it turned over to. We will facilitate a order that he can sign, have it turned over to them.
Do you already have that information?
Yes, I have name and address.
Okay. All right, well, that's noted for the record.
Thank you, Judge.
And Judge, I was going to mention one more thing too, and I told Mr. Hansard this isn't something that the court or the DA's office controls, but most of the time that he's been in jail, so for almost 2 years, he's been working as a trustee for Precinct 3, and I told him that it's kind of up to either the commissioner or the sheriff, the jail, to make that decision if they want to try to see if he can continue to work there while he's serving this sentence. But that would be up to them. But I know the state said they didn't have any objection to doing that as long as that worked out with basically with the folks who had the final authority on making that decision. So,
State has no objection. If he is useful to the Van Zandt County, we would support that, but that is, again, not something we can agree to, or we could oppose, but we do not oppose.
All right, that'll be noted for the record. This court doesn't have jurisdiction to order that, but it will be noted for the record.
Thank you.
All right, who do you want to call next, Mr. Sanders?
Judge, we can do Scotty Petty.
Scotty Petty. CR 21-365. Mr. Petty is set for a docket call today, as he was on Tuesday.
Yes, Your Honor. And Judge, we would just ask, I think the offer had been 10 years TDC, and he wanted to reject that offer and have this set for a jury trial.
All right, court will set Mr. Petty for jury selection beginning June 6th. Obviously, Mr. Petty's case will not be reaching trial that day, but he will begin the jury selection waiting list on that day. So, Mr. Petty, if you're still in custody, then you'll receive a notice as to when your next jury selection is. If you make bail in this case, then you're required to be downstairs in the courthouse at 8:30, and a member of my staff will be there.
And just, I just wanted to kind of clarify, on Tuesday, there was a dirty drug test, and that's why his bond was found insufficient. Is that correct?
Well, that and he left the court and didn't return.
Okay.
The reason I left was because I asked Mr. Waddell, and he said I was free to go, so that's why I left. Or otherwise, I would have stuck around. I didn't know that I wasn't. I mean, because I walked, right out. So I mean, didn't know I wasn't supposed to leave. But I would have been right here, if I would have known. But I asked him, so I didn't know.
Okay, I'll follow up with Mr. Waddell. He's not informed me anything of that nature.
Okay. Well, I mean,
But I told
Yeah.
Mr.
The
Petty
result
that
would be the same.
that's what we
Well,
talked about, that
Yeah.
whether he had permission to leave or not.
I didn't know what.
There was
Yeah,
no
I
drug
didn't know
test.
why I was arrested. I didn't know why I had a warrant, so that's what I was trying to figure out.
Do you have the new bond amount handy? Because he was asking about that, and I wasn't sure.
I'll post it up. It's 50,000. All right, who are you ready on next? Justin Harrell, CR 21-263. Go ahead, Mr. Sanders. We're set for docket call, I believe.
Yes, Your Honor. And talking with the state today, we've received a new offer that I was wanting to have some more time to talk to Mr. Harrell about, but also I think there's another matter the state was going to look into. So we were going to ask if we could have it set for another docket call in 30 days.
We were waiting quite a while on CPS records, weren't we, in this case?
We had got those turned over to Mr. Sanders in the last couple of weeks in accordance with the court's order. So that is the reason for the several resets we've had so far, and I did extend a new offer this morning, so I feel it's only fair to give them time to
Okay, court will reset. Mr. Harold, I'm gonna put you back on the regular docket rather than the contested docket. Are you available? Upcoming dates I have are June 2nd, 14th, or 16th.
June 16th will be fine.
All right, court sets Mr. Harrell for final docket call on June 16th at 1:30. Here we go, Mr. Ellis. Donald Ellis, CR 19305. All right, we are set for docket call in this case, Mr. Sanders.
And Judge, in talking with Mr. Ellis, I know that the court was aware there was issue with testing and retesting of DNA, and then still the possibility of what had been tested being retested. And talking with him, it's his desire to have a retest of the YSTR done. So I was going to ask for some additional time to allow for that, just from what he's indicated to me, he was wanting to have that done.
We already had testing on that. We're requesting additional testing.
Yes, Your Honor, and I believe this request has been previously made, but to my recollection, there was an issue with funding that retest. Request made, but no funds to that with, if I recall correctly. The state has had it tested by the state lab and has produced that. We don't necessarily have any objection to the defense having that retested, but
What was the result of the court granted the order to pay services of an expert? The court granted, it was Ms. Beasley's motion, and the court ordered payment of $1,000 to Ms. Yuma Nasir for advising and consulting with Ms. Beasley in regards to the DNA evidence in this case. Was that not associated to retesting?
I think my understanding of it all, Judge, was that there was a determination of male sperm cell, but it wasn't where it determined Mr. Ellis's DNA. That was my understanding of how that had played out. So I think that was maybe done about a year ago, 8 months ago.
There was a motion before the court, and the court denied funding.
Judge, this has been Ms. Curry's case, so I'm trying to work off of my recollection and trying to review the case here. has, sent me an update by text message. I'm going to step off the way, call Ms. Curry, and make sure I have accurate information.
Please. Mr. Ellis, if you just want to have a seat right there, just sit down on that first pew, right? Yeah, that's fine. Just. All right, go ahead, Ms. Heisel, update.
Thank you, Your Honor. After speaking with Ms. Curry, the court did grant the defense's motion, and to our understanding, everything he asked for has been given to him. With regards to the DNA testing, the state has submitted it for YTSR results, but that has not come back yet. However, the state is ready to proceed to trial, and we are going to ask for the court's special setting on October 3rd. That was previously scheduled and that case has been dismissed. So we currently have an opening in the special setting calendar. And I believe that with the special setting, perhaps the lab with an end date in sight will help us get those results back sooner rather than later.
Is the YSTR something the state was testing anyway, or the state is testing it at the request of Mr. Ellis?
Your Honor, I don't know the answer to that. I do know that the state is willing to proceed without it should we need to do that. But obviously, if we have it back, then that's best for everyone.
Mr. Sanders, in my review of the record and my recollection, I've not seen a motion for additional testing, additional DNA testing. I've seen the request for expert services, and the court granted that. That was ex parte. The court granted that and provided the expert that Mr. Ellis, that Ms. Beasley requested for Mr. Ellis. And I believe that she's received, the court's paid that bill already. So, granted that. So, if you follow a formal motion outlining what issues that you want the court to take up, then we can reset it. So I'll grant the state's request for a special trial setting in August. I'll send that notice out. I'm sorry, October.
And so just so that I'm clear too, so it is in the process of being tested.
It's been submitted to the lab. That's something we were doing anyway for Ms. Curry. And so it is at the lab. I'm just not sure where in line we are. But from my experience, the lab, we have a trial that we can submit to them that helps them get us faster.
Prioritize it.
Yes.
And that special setting would be what date do you have, Ms. Heisel?
October 3rd, Your Honor.
All right, the court will set Donald Ray Ellis, number 1 for the week of October 3rd, 2022. Should any motions need to be filed, Mr. Sanders, file your motion. You can request a hearing before then. The court will calendar you and docket you for that. And then if there's any additional issues with the additional DNA testing, bring it. either state or defense can bring that to my attention. Ms. Heisel, that was Mr. Morrison that was set and has fled. Is that what you said?
Your Honor, it's been dismissed.
Been dismissed. Mr. Manning, are you ready on Ms. Shelton? Is your witness here? Okay. Is that all you have, Mr. Sanders?
It is.
Yes.
Oh, and I want to let the court know, with Ms. Kaufman, who was supposed to be here this morning, I told her, or asked her if there was any way she could get here this afternoon, and she wasn't able to. I think that at first she didn't realize that we had court this morning, and so from her reaction, she may not have paid attention to the date that was on the reset notice, and when I told her about it was on the notice that we signed, and then that kind of, the tone changed when she realized that she had just messed up. So that's kind of where that is. So,
Well, if she calls you again, tell her she can turn herself in at the jail and we'll get her to court.
okay.
Otherwise, we'll find her. Thank you. I appreciate the update. Yeah. Rochelle Shelton, CR 18337. Ms. Shelton, you can come up to the table here. All right, Ms. Shelton is set today on a motion to revoke. Is this a contested hearing today?
Yes, Your Honor.
It shows.
All right, State, are you ready to proceed?
Yes, Your Honor.
Mr. Manning, you ready to proceed?
Go ahead,
Ms. Heisel.
Thank you, Your Honor. We would call Jarvis Crawford to the stand.
Mr. Crawford? Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Succeed. All right, go ahead, Ms. Heisel.
Thank you, Your Honor. Mr. Crawford, how are you presently employed?
Vincent County Probation Department.
And what are some of your job duties as a probation officer?
Supervise individuals that have been placed on probation and follow the rules of, or help them comply with following the rules of the conditions of probation.
And is Rochelle Renee Shelton on your caseload?
Yes.
And when did she get assigned to you for your caseload?
December 2nd, I believe, of 2021.
Okay. Was she placed on probation prior to that time?
Yes, she was placed on probation November 4th of 21.
Okay. Was that November 4th? Was that her first reporting date to probation?
Yes.
Okay. And did she appear on that November 4th date?
Yes, she reported on that date with the Officer Gain.
Okay, with Officer Dan. And then in December, she transferred to you.
Yes.
And did Miss Shelton appear at any of your scheduled meetings?
No.
Did she ever make a payment towards her fines?
No.
Towards her court costs?
No.
Did she complete a single hour of community service?
No.
Did she do her required drug offender education course?
No.
What is probation's policy when someone misses an appointment with you guys?
Get in the office or contact the officer to try to get in the office as soon as they can
Okay.
before the month is out.
And at intake, do people being placed on probation, do they provide you with mailing addresses and phone numbers?
Yes.
Did you try to contact Ms. Shelton at either or both of those methods?
Yes.
Was it one, the other, or both?
Both. Sent letters and phone call and email.
Did Ms. Shelton ever call in to you guys to explain what might be happening to prevent her from appearing at probation?
She did. We communicated by email a couple of times. If she weren't able to make an appointment, well, we had one appointment scheduled, and she would email and notify me of situations that were going on, so we would try to work to reschedule, but she never came into the rescheduled appointments.
Okay. So you gave her opportunities to make up the things that she had missed. Is that correct?
Yes.
I see in this violation report specifically the date of February 7th, 2022. She failed to submit to UA.
Yes.
Why that specific date? Was that a scheduled appointment that she just didn't show up for?
I had received an email on the 3rd from someone claiming that she'd been using drugs and abusing drugs. So I called her in for a UA that day. But I did speak with her on the phone. She answered that day and we spoke, and I told her she needed to come in for a UA. And she said she was going to be there. I gave her until 5 o'clock that evening, but she failed to report.
Okay, so that was outside of her regularly scheduled appointment.
Yes, we didn't have any. I think it had been a month or two since we had an appointment scheduled because lack of contact. So.
I know Mr. Gann is not here, but does he work in your office?
He does.
Do you share notes within case files back and forth?
We do.
Okay. So if she were reporting to him or contacting him, you would have known about that. Is that correct?
Yes.
Okay. So to your knowledge, she was communicating only with you and no one else in your office.
Yes.
Did she also fail to complete a substance abuse evaluation?
Yes. I didn't receive any record that she had. So.
And I see in the violation report submitted that she failed to pay UA fees for each month. Would those fees have been assessed regardless of whether you tested her or not?
Yes.
Okay. Your Honor, I pass the witness.
Mr. Manning.
Thank you, Judge. Mr. Crawford, so just to summarize your testimony with the state, you were supervising or had supervision over Ms. Shelton for approximately 3 months. Is that correct?
Yes.
And as you testified, during that time, you had no contact with her other than phone calls and emails. Is that correct?
Yes.
Could you specify how many times you spoke on the phone to Ms. Shelton?
I don't recall an exact amount of times.
Was it a few times or many times?
A few times, I would say.
More than 5, less than 5?
Less than 5, I would say.
Did you also communicate with her via email?
I did.
Okay. And was she responsive to your communications via email?
Actually, she would email me and I would respond, and that's kind of where it would end.
So she would reach out to you and contact you?
Yes, she did reach out at least 2 times, and I would respond, but nothing would go from there.
And you testified that you began your supervision of Ms. Shelton on the 22nd of December. Is that correct?
No, she came in for an intake on November 4th of 21. Tacoma services were requested, so I put in the referrals and did that, and she went, and that was taken care of. And so appointment was made with me on the 2nd of December.
I'm sorry, I didn't hear that.
And you didn't hear any of it, or
The last part. Appointment was made when?
for December 2nd?
December 2nd. Okay.
Yes.
You mentioned Tacoma. Can you explain to the court what that request is?
It's requesting mental health services through the interest center. We partner with the interest center.
And that was done by Ms. Shelton? Or was that done at your recommendation?
The request was done by me, but Officer Gann was speaking with Ms. Shelton during the intake. I don't know who brought up what, but I was brought in, and that's when the request was made.
So at some point, these services were requested or the probation department felt like she could benefit from Takumi's services. Is that correct?
Yeah.
And what is, we're throwing this acronym around, what is Takumi?
It's hard to remember off the top of my head.
Let me rephrase. Would it sound fair to say that Tacoma is Texas Correctional Office on offenders with medical or mental impairments?
Yes,
And that's put out through a statewide service through the state of Texas for mental health individuals. Is that correct?
I'm not sure if it's a statewide service, but the Andrew Center is partnered with the Andrew Center. So.
Do you know if Ms. Shelton was able to make those appointments with her Tacoma case manager?
I received notes that she was not making her appointments with the Andrew Center.
And who did you have as her Tacoma case manager?
Jennifer Landry, I'm sorry.
What type of individuals were placed on that particular case?
As I mentioned, anyone that requests to qualify for mental health services through
Do you have to qualify? What
yes.
are the qualifications for that?
A few include anxiety, depression, bipolar, schizophrenia, things like that.
So at some point there was a determination made that Ms. Shelton qualified for one of those categories and may benefit from this program. Is that correct?
Yes.
And did she come to you by way of the mental health caseload? Is that why you were handling her, or is it just part of your general caseload?
Yes.
Yes to what part?
She came by way of the mental health caseload by requesting the services for the Andrew Center and being accepted through those services. She came to my caseload, yes.
And I didn't hear if the state asked you, but you are qualified as the mental health caseload worker for Mainland County Probation Department. Is that correct?
Yes.
Okay. And have you received special training and certification in the mental health caseload?
Yes, we go to training and conferences. Yes.
Do you recall probationers' specific communications about her struggles and an ability to make it to probation in the probation department?
Remember at one point, one of the emails had mentioned not having a ride. And I think maybe on a different instance, a grandson or son falling ill to COVID and potential emergency room visits. But yeah, I don't remember all of the details.
So she provided you some reasons why she wasn't able to make it.
Yes.
Obviously, everybody has a story. Everybody has a reason why they can't do something, but she provided those reasons to you. Is that correct?
She did.
Okay. Did she also mention to you that her daughter attempted to commit suicide on December 26th of 2021?
Maybe I don't remember if she said that specifically, but I remember her mentioning something about her daughter.
Okay. And did she mention to you that she had sole care and control of her 3-year-old grandson due to the situation with her?
That may have been in the email.
Did she communicate with you anything about her work schedule or about her attempts to make it to probation or anything along those regards?
Like I said, I remember mentioning not having a ride. I can't recall anything about work schedule or anything.
Did she mention to you that in January 2022 that she was in a car wreck and her car was totaled?
Not that I recall.
Did she discuss with you that she was in the process of getting a car from a family member, or at that time it wasn't registered and insured at the time?
I believe that may have been one of the emails. Yes.
Okay. And did she also communicate to you that, at least at the beginning of probation, that she was not employed but receiving employment here and there?
Yes.
And did you ever receive confirmation of her employment?
Not that I recall. No.
Are you familiar with the 4 types of punishment that are kind of used in the criminal justice system?
Which punishments are you? I mean, I am familiar with criminal justice sentence.
But are you familiar with the retribution, deterrence, rehabilitation, incapacitation model?
Yes.
Okay. And what would you say that probation kind of fall? What umbrellas would you say probation falls under from those 4 models?
It could fall into different categories. I think the main focus would be rehabilitation.
Do you guys also provide opportunity for deterrence from specific behavior?
Well, yes, I believe it could fall into different categories.
And you do that through your analysis tests,
Yes.
you do that through classes, you do that through the services that are offered.
Yes.
And what about retribution? Do you guys provide opportunity for the probationer to make whole the county, victim, whoever they owe money towards?
Yes.
Do you know if any of those opportunities are available if someone were to be sent to state jail? Will they be able to get rehabilitation?
I mean, I'm not familiar with all of the things that are available in the state jail.
Are they able to, if they're in state jail, are they able to work and pay money towards fine, court costs, or financial obligations to work on the court?
I wouldn't imagine that.
Your Honor, at this time I pass the witness.
Tizer.
Mr. Crawford, does rehabilitation require participation from the subject?
Yes.
Does deterrence from, let's say, relapsing on drugs, that accountability, does that do any good if they won't show up for a UA?
No.
Your Honor, pass the witness.
Is 3 months a extended period of time to have someone absent from probation?
Yes.
And when seeking to work with someone who has been absent from probation, are there different methods that you can take to kind of get them back in, get them the help they need?
We send out letters. Letters are mailed out to notify the probationers they missed their reporting for each month.
And at any point in time, would those letters include the warnings about warrants being issued and probation being revoked or anything like that?
Yes.
And what do you know what address those letters were sent to?
I don't recall the address we had on file, but I don't have that information on.
Pass the witness.
Tizer.
No further questions, Your Honor.
Thank you, Mr. Crawford.
Thank you.
Tizer, any additional witnesses or evidence?
No, Your Honor, the state would rest.
Mr. Meany.
Yes, Judge, I'd like to call Ms. Jamie Wyatt.
Ms. Wyatt, if you'll come forward, please, to the witness stand. Yes, ma'am. White, if you'll raise your right hand. Now, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? The chair moves, right, turn it, make yourself comfortable.
It's a seat.
Give your testimony to the court, they speak up loudly and clearly so we can all hear you. As the attorneys are talking, allow them to finish your question before you hear the answer. We'll continue that sequence. Okay?
Yes, sir.
Mr. Manning,
Thank you, Judge. Ms. White, can you please state your name for the record?
Jamie Wyatt.
And what is your occupation?
I am the retail manager for Bruce Miller Nursery.
How long have you been working with Bruce Miller Nurseries?
Just over a year.
And how long have you been a resident of Van Zandt County?
26 years.
When did you first, approximately, when did you first come in contact with Ms. Shelton?
I believe it was at the very first of the year.
And that was this year, is that correct?
Yes,
Okay.
yes.
And how did you come to meet with Ms. Shelton?
She came in and applied for or filled out an application for employment.
And what type of employment was she seeking?
Cashier and general helper for us.
And did you end up hiring Ms. Shelton?
I sure did.
Approximately how long did she work for you?
I can't remember the actual hire date, so it was a couple of months, 3 months.
And how many hours would she work typically in a week?
Anywhere from 8 to 12. Depending on how many people we had working that day.
8 to 12 hours a week?
No, a day, excuse me. A week for at least 40.
And did you ever have any problems with her work ethic, showing up on time, doing what she's supposed to?
Never.
Did you, what were the type of responsibilities that you entrusted her with?
She was our lead cashier. She would get there in the morning. She'd open up the cash register. She had access to our safe. She did all of that. She helped me with programming all of our cash register stuff. We'd gotten a new system. She took care of our customers. She cleaned. Everything.
Any problems with her while she worked there?
Never.
Did she provide a benefit or service to Bruce Miller?
I'm sorry.
Did she provide a benefit or service to the nursery?
Absolutely.
And if she was able to go back and continue working with y'all, would you be willing to take her back?
Yes.
If she was released on some sort of work release program through whatever punishment the judge assesses, would you be willing to comply with whatever rules and regulations were put in place by this court?
Yes.
And besides you coming in contact with Ms. Shelton for employment, did you know her at any point in time prior to this?
Never met her in my life.
So your only exposure has been those few months that she worked with you and
Yes, sir.
that's your date.
Yes, sir.
all right, thank you, Ms. White.
Thank you.
Your Honor, may I have a moment?
You may.
Your Honor, at this time, I'd like to call Ms. Rochelle Shelton.
Sheldon, if you'll come to the stand. Best of your ability, raise your right hand. Now do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Succeed.
Thank you. That's good. Thank you.
All right, go ahead, Mr. Mayor.
Thank you, Judge. Ms. Shelton, you've heard the testimony of the various witnesses today. In hearing that, was the testimony given by Mr. Crawford accurate as to your involvement or participation in the probation department here in Benton?
Yes, sir.
And were you a part of the Takumi program offered to do again yourself?
Yes, sir.
Why were you requesting or put on that docket?
Because I have some mental health things that I wanted to try to overcome or get help with to live a better life.
And more specifically, what were those mental health issues you wanted to overcome?
PTSD, depression, anxiety.
And when you met with Larry Gam, was that something that they were able to clear you for and qualify you for to put you on the docket for the mental health caseload?
Yes, sir.
And did you in fact have opportunity to meet with Jennifer with the mental health caseload?
Yes.
And how many times did you meet with her?
I only met with her a couple of times, but I was in contact with her weekly, so sometimes every other day, but we were both going through some of the same things at home, so we stayed in close contact.
Okay. And is it typical in kind of today's post-COVID atmosphere for a lot of these meetings with your mental health advisor or therapist to be done over the phone or Zoom calls or electronically?
Yes, they were all over the phone. My doctor's appointments and everything took place by phone.
And as part of your treatment, did they assign you any medication or any therapy?
Yes.
Okay. What was that?
They prescribed me Vistaril and Remeron, and that was it.
And what were those supposed to assist with?
The Vistarils for depression and PTSD, and the Remeron helps me sleep.
When did you begin taking those medications?
I started taking the Vistaril in October of last year. The Remeron was November, I believe.
What happened in December of 2021 that kind of shook up your life and made things a little more difficult?
Well, my grandson had came to stay with me because my daughter's mental health wasn't well. December 26th, she wrote a note to me and her fiance, and a suicide note, and we got those notes and were able to pinpoint her location and called 911, and they met us at the scene where she was at and got her to the hospital in Tyler.
Why was she needing to go to the hospital?
I'm sorry?
Why was she needing to go to the hospital?
Because she had ingested a lot of Seroquel that she had been prescribed.
How old is your grandson?
He's 3.
And were you the primary caregiver from beginning of December up until your most recent incarceration?
Yeah, yes, I actually in the beginning of November last year, I had started taking care of him, and when I got him, he had been real sick, and the beginning of November is when I got him.
Did you have a job when you began probation?
No, sir.
And did you seek out employment?
Yes, sir.
Where did you end up getting employed?
At Bruce Miller Nursery. I applied online.
And how did you get to and from the nursery?
I was able to use my mom's car.
You had a car, is that correct?
Yes,
And what happened to that car?
I wrecked it.
When was that?
November, December. I can't.
Did you feel like at the beginning of February that you were just kind of getting your life back together and feet underneath you?
Yes, sir. I was feeling really good about life, getting a job and getting to work and trying to take responsibility and accountability. And I was grateful for the people that I did get a job with because they've been amazing to me.
But you realize that at no point in time had you complied with conditions of probation that you had placed on.
Yes, sir.
And you realize that according to the testimony from the probation department, what the judge has before him, he doesn't have a real good track record for you over the past 3 months for your ability to comply with the conditions that you placed on in the beginning.
Yes, sir.
You understand?
Yes, sir.
And you also understand that at this point, he's looking at the full range of punishment, which is up to 2 years in the state jail facility. And that's kind of what the decision he's faced with at this point in time.
Yes, sir.
And being here, what would you ask the judge to do, given that you weren't successful in the 3 to 4 months that you were on probation and the conditions that he placed on you to begin probation?
Just to be on work release, that I have good people behind me that would be sure and guide me to help me handle the things that I need to take care of.
And when you mean work release, what specifically are you asking for?
To be incarcerated here in Van Zandt County and to be able to go work every day at Bruce Miller and come back.
And you realize that if the judge granted that, he would put on restrictions to your time when you'd be released. Is that correct?
Yes, sir. I'm sorry.
Okay.
I spoke to the lieutenant at the jail about it, and she was very informative on what the guidelines and things are.
And did she warn you what would happen if you, as you did in probation, failed to live up with the conditions or requirements of the work release?
Yes, sir.
And what would those potential results be?
And being incarcerated, state jail.
And if you didn't show back up at the time you're supposed to, what would happen?
I would be arrested or have a warrant put out for my arrest.
And face potential new charges?
Yes, yes, sir.
Okay. And you've spoken to Lieutenant Harrelson at the jail about this, is that correct?
Yes, sir.
And while you've been incarcerated since your arrest, have you had opportunity to assist while at the Van Zandt County Jail in a trustee type status?
Yes, sir.
Okay. And understand that you're not a trustee, is that correct?
That's correct.
And that's partially due to the facilities and the jail rules and regulations regarding male-female contact in custody, is that correct?
Yes, sir.
Okay. But is it not true that sometimes in the evenings you get out, you clean the halls, you assist with in the offices under the supervision of Lieutenant Harrelson, is that correct?
Yes, sir.
Okay. And that's a voluntary thing. She's not forcing you to do that, is that correct?
Absolutely. I volunteer for it.
And you've done that knowing that that's not going to sway your standing here.
Yes, sir. That's correct.
You don't have to pass the witness.
Thank you, Mark. How old is your grandson?
He's 3. He'll be 4 in July.
Ms. Heisel, can you turn on your mic? Sorry.
And you said he was sick when you kind of took possession of him. What month was that?
At the beginning of November.
Okay. How'd you get him back and forth to doctor's appointments?
My daughter.
Did your daughter have a car at that point?
Yes.
When did you get access to your mom's car?
Would say about January of 22.
And so starting in January, did you call the probation department and say, hey, good news, I've got access to reliable transportation. See you guys soon?
I did contact Jarvis and Jennifer both, but my concern was that the car wasn't legal to be driving. Yes,
But you were driving it back and forth to go to work, right?
yes,
And you were going to work every day.
yes, ma'am.
And I think you testified that prior to that, before getting your mom's car back in November, that you went in person a couple of times to Kumi. Is that correct?
Yes, ma'am.
Do you remember when that was or how many times that was?
I can't remember when it was. No, ma'am.
How did you get there?
My step grandmother took me.
Ms. Shelton, you showed up for probation the first time and you did intake, and it appeared that everything that you've requested in terms of mental health help and all of those things, they were going to be cooperative with, correct?
Yes, ma'am.
And you were able to contact them and reschedule if something came up. Is that true?
I don't recall having to reschedule anything with Tacoma.
I'm sorry. I'm talking about with probation. I'm
Oh.
sorry for the confusion.
Yes, ma'am.
Okay. So you knew that that was an available option to you.
Yes,
Yet you never showed back up.
that's correct.
So why should we believe that if you are given work release or any other kind of program where it's up to us to trust you that you're going to come back, why is now different?
Just because I'm gonna do better. That I'm gonna do better.
Do you recall back in October of last year when you came to this courtroom and you signed up for probation? Do you recall the court telling you what the penalty for not successfully completing your probation was?
Yes, ma'am.
What did he tell you?
2-year state jail.
That's right, 2 years state jail. Your Honor, I would pass the witness.
Mr. Manning?
No further questions.
All right, thank you, Ms. Shelton. Any further witnesses or evidence, Mr. Manning?
Nothing from defense. I apologize. I do ask the court to take judicial notice of House Bill 2158, which was proposed for a work release program this last legislative session. In it, it outlines various guidelines to ease overcrowding in state jail facilities, as well as provide assistance with the problem of recidivism, specifically in the state jail. It also talks briefly about the financial responsibilities, and I asked the court to specifically note that it is seeking to legislate what is currently done periodically in counties throughout Texas to recoup costs for the county, and also as well as recoup costs for supervision while someone is on work release. The proposed bill, and it is just that, it's not been passed at this point in time, would allow any cost associated with the housing, transportation, or supervision of an inmate that's on the work release program to be recouped at 25%, as well as any amount necessary for court costs, court order, financial responsibility to be recouped from the wages of the individual as they're on work release. As you've heard testimony today, Bruce Miller is willing to take her back. Both Mr. Miller and Ms. Wyatt have spoken to me about that. And so we request that if she is sentenced to state jail, that she be given an opportunity to participate in that work release program here in Benson.
So the work release program is administered by the State Jail Division of TDC.
Judge, there are, at this point, there is not a legislation on the books for a state jail program to do that. That what they do have is informal programs through each of the local counties that they set up their own work release programs. I spoke to Lieutenant Harrelson, who conveyed to me that in the past, that has been something that's been done with mixed success for inmates that are sentenced to TDC or state jail that could be housed here and participate in a work release program that's supervised from Manzing County. But this time I was unable to locate anything on the statewide level specifically for state jail that would allow that type of work release that's been legislated by the state.
Does Manzing County have such a work release program?
According to Ms. Harrelson, they do, but that would have to be ordered by the court for her to be put on that program. And once she's put on that program, they would administer that program for the court's orders.
But it would require a sentence to TDCJ.
Judge, as to the specifics of that, I'm not sure how it would best be done. I spoke to the state about possible options for that, whether it would fall under 1244A or whether she would be sentenced to whatever term of confinement under state jail, and then we petition the TDC board for her to remain here like other inmates have for TDC institutional commission.
Thank you, sir. Ms. Heisel.
Your Honor, first I would just like to address the work release program. Manzing County does have their own version of that. I have also spoken with Lieutenant Harrelson, and I think Mr. Manning is correct. I think in order to qualify for that, the court would have to assess punishment under 1244A for county jail time, because from what I'm being told by Lieutenant Harrelson, Ms. Shelton is not somebody that they would sponsor them serving state jail time if that's what the court assesses in our jail. That she's not a person that they would sponsor for that option, although that has been done in the past. Your Honor, it is our position. It went out in early October, a notice to all defense counsel that starting in October, the state's policy was whatever sentence was imposed at the time of the plea, that negotiations for exposure would be had up front, and whatever the plea was for, that sentence was imposed as of that day. Your Honor, we made all defense counsel aware of that, and I know Your Honor also admonished every plea that came through this court that it wasn't going to be a discussion after the fact of up to whatever the exposure was. It was just going to be what the exposure was. Your Honor, that's what we're going to ask for today. I know Ms. Shelton has had some challenges and some struggles, but Your Honor, everybody does. And the reality is that she made it to Takumi when she wanted to make it to Takumi. She made it to her grandson's doctor's appointment. She made it to work, but she not one time made it to probation. Not even after probation allowed her to reschedule to work around those complications in her lives. So it's our position that she didn't even try to do probation, and the consequences of that should have been fresh in her mind since she only took a plea 3 months before that, at which time I know the court admonished her what the consequences would be. So we're going to ask the court to impose this or to carry out the sentence that has already been imposed in this case.
Judge, I'd like to correct one thing, and that is the state said that she never made a probation appointment. That's false. That's by the testimony of Mr. Jarvis Crawford as well as my client's testimony. She came 1 month after she was released from jail. She was put on probation, and she reported clear again. She got this process started, and then life fell apart. And Your Honor, she admits that she didn't do what she was told to do. She admits that she wasn't responsible with the conditions that were put on her by this court. And she's not asking to put back on probation, Judge. All she's asking is that, in looking at the 4 types of punishment, that you craft and tailor a punishment for this situation, for this defendant, and for these facts. Judge, it's not a max case. There's a possession less than an ounce on the mandatory probation case, Judge. And she was given off from 2 probated for 2. In looking at the 4 types of punishment, if we incapacitated her, then we take away the ability for rehabilitation, we take away the ability for deterrence, or retribution in this case. Her fines or court costs should be put on a pay when she gets out and be able to pay those as needed. Whereas if she's given the opportunity to stay here in Madison County and work at a known location with a known employer who's coming and taking time off from work today to testify on her behalf. If we have that opportunity, not only will she continue to be incapacitated from being able to do the type of things that she wasn't supposed to be doing in the first place, but she has an opportunity to get back, compensate for her mistakes and learn from this while staying here. So we ask that whatever sentence may be imposed, if it is for term, she get an opportunity to do that on work release here.
Thank you, Smith. All right, the court's going to take the evidence. The court will take judicial notice of House Bill 2158. I will review that. The court's going to take the arguments under advisement. The court's going to stand in recess for a bit, and then I will come back out and render sentence. All right, we are back on the record. Cause number CR 18337, State of Texas versus Rochelle Renee Shelton. The court has considered the evidence. Court, based on the testimony of Mr. Jarvis Crawford and on that of Ms. Rochelle Shelton, the court finds that Ms. Shelton has violated the terms and conditions of her community supervision. The court finds counts 1, 2, 3, 4, 5, 6, 7, 8, and 9 to be true. Based on that, the court will revoke Ms. Shelton's community supervision. Court assesses punishment for Ms. Shelton on a couple of grounds. One, the court has reviewed the evidence. Court has taken judicial notice also of the file. Court has reviewed State's Exhibit 1, which supported the plea, which Ms. Shelton accepted a plea agreement for the state jail felony offense of possession of a controlled substance, penalty group 1, less than 1 gram. Court finds that Ms. Shelton, prior to being placed on community supervision, failed to appear in court on 2 occasions, October 23rd, 2018, and also April 1st, 2021. Court finds that she is no longer a candidate for community supervision. Court will impose the sentence originally imposed by the court on October 26, 2021. Court hereby sentences her to 2 years confinement in the State Jail Division of the Texas Department of Criminal Justice, and orders her to pay the balance of her financial obligations. The court will award Ms. Shelton all credit for time that she has spent in jail on this cause. Ms. Heisel, I'm going to direct the DA's office to prepare a judgment, to provide that to Mr. Manning, and to provide that to the court. Anything further, Ms. Heisel? Mr. Manning?
Judge, I don't know the policy of the court here in Banjo County, but we asked that she be given presumptive credit for good time credit under state jail policies. I don't know if the court reviews those applications that come in.
Yeah, so how it works is the Texas Department of Criminal Justice will notify the court electronically, and whenever she reaches the mark of her sentence, we'll notify the court, and they TDC will report to me any classes that she's taking. Also will report to me any disciplinary conduct or lack thereof. And once that's presented to the court, then the court will review that information and make a decision on whether to grant the 20% or not. The court will review that once it's presented for Ms. Shelton. And the court does review that. The court does review that in detail. I do review the disciplinary history. I do review the efforts at rehabilitation and education. Right. So if there's nothing further, then we'll be adjourned in this case.
Judge, that's all business the state has to excuse.
Yes, and so will the judgment be presented tomorrow sometime?
It'll probably send an email to both you and Mr. Manning.
Okay. So once we get it, then we'll take it out to the jail and get a fingerprint for Ms. Shelton.